Everybody. Good morning, everybody. I'm Tuesday Sigmund. I'm the chair of the Disability Services Advisory Board, and we really appreciate you joining us today. This is Disability in a Week. We moved virtual last year, and we decided that it would be a good idea to continue that this year as well. We look forward to Disability in a Day next year when hopefully all of the restrictions have adjusted quite a bit. So the Disability in a Week will last the entire week of June the 7th through the 11th, and from 10:30 till 11:30 each day. Just a brief overview, you would have received the agenda when you signed up for the conference, but today we get the opportunity to hear from some attorneys from the Office of Civil Rights. We certainly appreciate them being with us today. Tomorrow, we will hear from Dr. Whitney Griffith, diagnosing and supporting college students with specific learning disorders. On Wednesday, we'll hear from Kim Schufrin from the ICANN House about autism awareness. We'll have Dr. Griffith back with us again on Thursday with diagnosing and supporting college students with attention deficit or hyperactivity disorders. And we're going to round out the week with a discussion panel about requesting accommodations and technical standards from some of our veterans in the field. This is our advisory board, and we wanted to let you know a little bit about who we are. So of course, our liaison at the system office is Trudy Hughes. Many of us are very familiar with Trudy. She is always willing to answer questions that we have. Myself, Tuesday Sigmund, Renee Macemore is our current treasurer, and Jason Rastron is our secretary, Jason. We have Laura Bracken, Casey Groover, Amy Helmus, Lisa Kelly, Megan Sherman, Starlet Vault, and Holly Wagner. We are going to have some adjustment to the board, and in the evaluation at the end of the week, we are looking for new board members as some of us are rotating off due to new positions and various reasons. Just a few reminders, please hold your questions to the end of each presentation and mute your mics during the presentation. The link is going to be the same each day. So the link that you joined us today will be the same link that you'll join every day with us at 10:30 this week. Again, Trudy will be sending out that survey at the end of the week. So please make sure to fill it out because we would like your feedback on how Disability in a Week went, and reach out to anyone on the board if you have any questions or concerns. I did want to take a moment to introduce our attorneys that are with us today. We have Betsey Trice. She is the senior attorney with the Office of Civil Rights, and she's been with the Office of Civil Rights, the DC Enforcement Office, since its inception in 1996. She received her BA from Vanderbilt University and her Juris Doctor from the University of North Carolina, Chapel Hill. So North Carolina, we appreciate you being with us. Kathryne Love is an attorney at the DC Metro Regional Enforcement Office. She joined the department in 2016, but prior to that, she spent over a decade in private practice, handling large-scale commercial litigation, as well as maintaining an active pro bono practice involving youth advocacy and legal services. She received her Juris Doctor from Georgetown University Law Center and her undergraduate from the University of North Carolina, Chapel Hill. Jasmine Gibbs is our last attorney that's with us today. Jasmine is an attorney at the OCR's DC Metro office. She joined in 2019. Prior to coming to the OCR office, she worked as an equity officer and a Title IX coordinator at Santa Fe College in Gainesville, Florida for 3 years, and as a Title IX program officer at Harvard University for 3 years. She received her BA at the University of Miami and her Juris Doctor from Emory University. So without further ado, I turn it over to you ladies. I'll stop sharing and allow you to share your presentation.
Thank you so much, Tuesday. Appreciate that. We appreciate the invitation to be here. We appreciate your patience this morning. Technology isn't always friendly to us, and we're finding that this morning, but we'll try to make up some time here. We have a bit of an ambitious agenda, so we'll just do what we can. We want to certainly entertain any questions that you have as well. So as Tuesday mentioned, I'm Betsey Trice, and Kathryne and Jasmine and I are all attorneys in the Metro DC Enforcement Office of the Office for Civil Rights. Our office covers the District of Columbia, North Carolina, South Carolina, and Virginia. And I'm just going to take a few moments to briefly describe our resolution process, because that's what we will be talking about, how individual cases have been resolved. And I think a little bit of background will help to understand. But just very briefly, you know, OCR, as I'm sure many of you may know, our mission is to ensure equal access to education and promote educational excellence through the enforcement of civil rights laws. And two of the laws that are kind of the bulk of our work these days is Title II of the ADA and Section 504 of the Rehabilitation Act. And we do our enforcement practices through receiving and resolving complaints of discrimination, as well as conducting compliance reviews, providing technical assistance, and the OCR generally develops policy guidance. So our jurisdiction involves entities who receive funding from the U.S. Department of Education or public entities, and all of those we refer to in our documents as recipients. So today we're going to discuss how several complaints that we received were resolved, and they're designated by docket number. That's how we've listed them in the presentation. And just a little bit of OCR trivia here. The first two digits of any docket number correlates with the OCR regional office where the complaint was filed. We have 12 offices nationwide. And the second two reflect the fiscal year in which the complaint was received. So our fiscal year runs from October 1 through September 30th. And I think it's at the outset, it's important to note that many of the complaints we received are not actually open for investigation. We have a process where we evaluate complaints at the outset for a number of elements, and many are dismissed because they either don't state a violation of the laws that we enforce, or they've been untimely filed, or we don't have jurisdiction for another reason. And so when we do dismiss a complaint or even an allegation within a complaint, the recipient institution would not know about that. We don't tell the entity that, about allegations that have been dismissed, or even full complaints that have been dismissed. And some of the reasons that trigger dismissal would result in an appeal within OCR, and our appeals are handled by different regional offices to preserve the integrity, of the appeal process. But for allegations that are open for investigation, there's several ways in which they're resolved. One of which is called the facilitated resolution between the parties. It's essentially an opportunity for the parties, the complaining party and the school institution, to resolve voluntarily issues without OCR investigation. And those matters result in an agreement that the parties sign, but OCR is not a party to, and we don't enforce them. We facilitate the dialogue and the resolution, but we don't enforce the agreements. Some of the other agreements that we're talking about today are called 302 agreements. They're named, they correspond with section 302 of our case processing manual, which is available on our website. These are situations where a recipient requests the opportunity to resolve a complaint. So a recipient institution can request to resolve a complaint through section 302 agreement anytime before OCR issues its findings. So it could be midstream, as long as we've identified some issues that could be addressed through an agreement. And these 302 agreements must be tied to the allegations that were presented and to the evidence that we've obtained so far in the investigation. Complainants typically don't have any input into what that agreement looks like. It's an agreement between the recipient institution and our office. We also will talk about 303A findings, which are insufficient evidence. That also correlates to section 303 of our case processing manual. We operate using a preponderance of evidence standard in all our investigations. And so if after we've reviewed all the documents, perhaps conducted witness interviews and done on-site inspections as appropriate, if we determine there's not a preponderance of the evidence to support a finding of discrimination, or that a recipient institution has otherwise violated the law, we would issue what's called an insufficient evidence letter. You'll also hear about 303B agreements, and that also is results after we've completed a full investigation and we've found by a preponderance of the evidence that discrimination has occurred. In this instance, we would negotiate the terms of the agreement with the recipient institution and require them to take appropriate actions to correspond with what we found to be a violation. Sometimes the agreements will result in individual remedies that flow from the original complaint. And it could also be systemic remedies as well. It depends on what we find. Typically we don't our investigations don't result in monetary damages or in, getting personnel fired. We're not looking from a punitive standpoint, we're just looking to make sure that the recipients have complied with the law. The cases we have picked today, we have chosen because we believe they're instructive decisions. They may present situations that you've encountered or otherwise might be familiar with, and we hope that they will help you in formulating your policy and practice with regard to your own campuses. Just as an overview, we're going to do quite a bit of focus on academic adjustments or short-term accommodations, including extended time on assignments in a clinical setting, whether provision of accommodations result in fundamental alteration of the college's program, accommodations for non-students, accommodations in a conduct hearing, provision of furniture as an accommodation, grievance procedures, and physical accessibility. So that's a broad sweep, and we hope to get to as many of those as possible. And just the last thing I wanted to say is we have some resources that are available on our OCR's website, which is www.ed.gov/OCR, which includes the copies of the resolution agreements that we will be talking about when a case has been resolved through that results in a resolution agreement. Both the letter and the resolution agreement are available on our website. We also have a relatively new outreach, prevention, education, and non-discrimination center, OPEN Center for short, and that offers the opportunity for targeted support to recipients and to members of the public. And finally, we're pleased to announce that OCR now has a blog, which is a source of even more recent information, including some information related to COVID-19 and school districts and college and universities' responsibilities. So we hope you'll peruse OCR's website for these resources and more. And with that, I'm hoping to turn it over to Kathryne to discuss the first case. Or if not, perhaps Jasmine, do you want to start? I think you're muted.
Am I unmuted? Oh, yay. Everyone, I really thank you so much for your patience with our technical difficulties this morning. I hope that we've provided context to that and given you some background as to why we're having the problems. I wish I could blame summer and the fact that this is June, and I hope that you're all as ready for that as I am. So let's go ahead and get started. As Betsey said, we have a broad sweep of cases we'd like to get through today. So I'm going to count on my co-presenters to help me not talk too much about any one case. The first case that we'll talk about today is, I think, a very fascinating one involving some concepts that everyone's likely already familiar with. As Betsey mentioned, we're going to be covering academic adjustments and accommodations. And the case also affords some good guidance on what constitutes a fundamental alteration to an educational program. First, I just want to sort of review the legal standard that we use and that you are probably very familiar with relating to an academic adjustment. So Section 4 and Title 2 require institutions to provide disabled individuals with aids, benefits, or services that is effective so that that student has equal access to the educational program and must also be provided in the most integrated setting appropriate to that student's needs. Whenever OCR is looking at an academic adjustment, we examine whether or not that individual with a disability has an equal opportunity to participate in the programs and activities of the institution, unless, and this is the fundamental alteration point, that doing so and providing that adjustment would be a fundamental alteration of the school's educational program or would constitute an undue burden. We look at cases presenting a fundamental alteration question by looking at whether in a post-secondary environment the institutions engaged in the interactive and deliberative process with students to determine which academic accommodations are appropriate and which of those accommodations will not fundamentally alter course requirements. So the interactive process is pretty critical, and what we look at, we try to, if we see anything that is a bright line rule related to an academic adjustment, and that's something that we would look at very critically to make sure that the school is engaging with each student individually and considering that individual student's needs. Whenever a particular accommodation that's requested by a student can't be implemented based on what is considered to be a fundamental requirement of the institution's educational program, then we like to see an institution exploring whether or not there is an alternative option for accommodating the student. So this case, 619-2279 is our internal docket number for this case, involved what I think is a pretty interesting academic adjustment consideration and one that I've seen in a number of cases. So it's a good illustration of how fundamental alterations and academic adjustments are considered in the context of clinical assessments. The student here was at a large university's Department of Veterinary Medicine, so vet school, and her disability was a sleep disorder. She had registered with Disability Services to receive extended time for tests, quizzes, and exams, and she was receiving those on all written quizzes, tests, and exams. But there was an end of course clinical piece of her of one of her courses that had a simulation model with actors and animals. And I kind of love picturing this. It sounds like some sort of a reality show, but playing out different case scenarios. And then the vet students were required to go through those scenarios or stations and respond clinically in real time. So the student had learned that she couldn't receive extra time on some of these clinical exam stations. So she reached out to Disability Services, and the Disability Services coordinator reached out to the professors in the program to determine which of these stations could be appropriate for extended time and which of those stations would require a timed response. Those were called emergent stations and required a response within a certain period. I think it was 5 minutes, because both of those involved life-threatening situations, simulated situations that would require immediate action. The school's position here was that the student's ability to respond quickly and effectively needed to be tested. One, for example, was suturing a wound and another was a recitation. And I don't really, resuscitation. I don't really know what cardiopulmonary cerebral resuscitation involves, but it sounds like it's time sensitive. So the student ended up failing one of those two emergent stations, which involved suturing, and also failed two of the stations where she was provided the extra time. The university offered her the opportunity to take the 3 stations that she failed, and she received the extra time on the non-emergent stations and then completed the suturing station within the 5-minute frame that was allotted, but failed it anyway. And the student alleged that she had been denied an appropriate approved accommodation because the accommodation wasn't provided in all the clinical emergent stations. So OCR really looked very carefully at what disability services had done and confirmed based on the information that was discussed that this was engaged in a process with the student, and that they went through a determination that providing extra time for those clinical exams would alter the school's academic requirements to ensure that program instruction included what the students needed to do in emergency surgical or life-threatening situations. And because the Section 504 standard doesn't require a recipient to provide any academic adjustment that would fundamentally alter that program or lower academic requirements, OCR determined that there was insufficient evidence to establish a violation, and we closed that case as a result with an insufficient evidence finding, as Betsey described. So I think this is an interesting example, as I said, of fundamental alteration in a clinical assessment, and I have seen this come up in a number of cases that have physician assistance programs, for example, and nursing. So just something to keep in mind. One other point about this that I find interesting is how the university communicates with the student and at what point in the process the university communicates with the student to ensure that the student has an understanding of when they would need to, for example, practice with a more limited time period. So here it seems like that the student wasn't made aware until very shortly before the clinical exams, and that was with the assistance of disability services. Still, in this case, there was an insufficient evidence finding because of the fundamental alteration requirement, but disability services here did what it needed to do to provide that interactive process. I am seeing that I need to wrap up on time, so I wanted to open it up and see if there's any questions about that. And if not, I'll turn that over to Jasmine. Any questions? I hope everybody could hear that okay. All right, I think we're ready for our next slide.
All right, so our next case is a case about the requirement to have a grievance procedure. And so this case, now I can't move my Zoom. That's weird. Just one sec. There we go. Okay, so this case is it's in a public university in the Mid-Atlantic region, and OCR investigated whether the school had discriminated against the student on the basis of disability by failing to respond to his complaint that a clinical instructor subjected him to harassment because of his disability during a clinical rotation at a physical therapy clinic. And so this, again, like the previous one, is something that we see sometimes as well. Students alleging that they're at a placement where someone who is not under the control of the school or the university perhaps discriminated against them. So the student was enrolled in the University School of Physical Therapy, and he was registered with the university as a student with disability. And during the summer of 2018, he was placed in a full-time clinical rotation at the clinic under the supervision of a private physical therapist who was the student's clinical instructor. So I'll call him the CI, the clinical instructor. The CI was not an employee of the university, and the student was the first and only student from the university to be placed at the clinic. Throughout the clinical placement, the complainant, the CI, and the university's clinical director had some discussions about the student's progress, including some difficulties that he was having when he was communicating with patients. The student did not report any concerns about the CI's alleged harassment during the time he was placed at the clinic, and the university didn't otherwise have any notice of the CI's harassment of the student during this time. After the clinical placement, the student and the school had a meeting to discuss his performance in the clinic. He was given an opportunity to share whatever he wanted to at the outset of the meeting, and he didn't share any concerns about discrimination. And he told OCR that the reason he didn't share that was because he didn't think the university would care. So the student passed that clinical rotation, but ended up getting dismissed in that December of 2018 semester for reasons that were related to another course. And so after he was dismissed from the school, he wrote an academic appeal. And during that academic appeal, he described the allegedly hostile environment that he experienced at the clinic. And so at this point, I do want to pause the chronological retelling of the facts to explain the university's complaint policy. And so the policy at the time provided that all complaints of discrimination must be reported to the university's affirmative action officer, and that any individual who has knowledge of harassment or receives a complaint of harassment should immediately inform the affirmative action officer. So it's the affirmative action officer who will determine whether to proceed with an informal resolution or a formal complaint. And this would include a prompt investigation of the matter. So back to the student's appeal. The student submitted this appeal to the school's executive director, asserted that the CI had discriminated against him on the basis of disability when the CI told him that he was, quote, strange and that he spoke silly. And he criticized his communication abilities, asked some specific questions about his disability. He also told the patient that the student had special needs, and that those comments caused the patients to refuse to work with the student. And he also asserted that the clinical director had told the CI that the student had a learning disability and that, quote, his mind was like a ping pong ball, end quote. So the university's clinical director responded to the appeal. She upheld the dismissal, but she did not address any of the disability discrimination allegations. She informed OCR that if a student raises any concerns with respect to his or her clinical placement, the school's practice is to transfer the student to another site immediately without any investigation or further reporting to any university administrator. So here, the university's dean or dean at the university instructed the clinical director to discontinue placing students at that clinic. And so he was the only one who ever went to that clinic. And 3 months after the student's appeal, the Office of Affirmative Action reviewed the complaint. And then the assistant director of the Affirmative Action office determined that the university would wait to proceed with the student's complaint until the affirmative action director returned from leave. And so as of the date of OCR's resolution letter, which was in June 2019, the affirmative action director had remained on leave, and the university still had not investigated the allegations of disability discrimination or taken any steps to remedy any harassment that may have occurred. So if we think about the legal standard here, there's a couple things I want to highlight for you. One is that Section 504 has a specific provision that states that a recipient that considers participation by students in educational programs or activities not operated wholly by the recipient, so that's a school, but that is part of or equivalent to an educational program or activity, the recipient shall assure that the other educational program or activity as a whole provides equal opportunity for the participation of qualified individuals with disabilities. Meaning that if you have a student at a program or at a placement that is part of your educational program, you do need to respond to any discrimination that is happening there. Of course, you are limited to what you can do or any actions you can take, but you do need to respond. In addition, Section 504 and the ADA require that schools have a grievance procedure that incorporates appropriate due process standards and that provides for the prompt and equitable resolution of complaints alleging disability discrimination. So in this case, there was a violation found, so that's a 303B. OCR determined that when the student filed his academic appeal, the university was then on notice of alleged disability harassment, but they did not promptly investigate that harassment. Also, there was the concern about the delay in investigation, right? Like they waited to until the affirmative action officer came back to do an investigation. And also OCR determined that the clinical program lacked an adequate process for reporting and responding to complaints of discrimination or harassment that arise in clinical placements. And importantly there, the process described by the clinical director to just switch students to another placement without an investigation is actually contrary to the university's own grievance procedures. So for all these reasons, there was a violation found. And so as part of the resolution to the violation, the university had to complete the investigation and had to provide training to the university administrators and staff, that covered the grievance procedures and the school's responsibility under Section 504 in the ADA. So that case underscores the importance of the grievance procedure in this case. I'm going to go ahead and do my next case, and then I'll see if there's any questions on these two cases. So the next case is a very interesting case, I think, about auxiliary aids for a hearing impairment. And so interestingly here, the complainant in this case is hard of hearing. He attended an event at a large public university in the Midwest where he was denied requested aids and services. So the complainant was not a student of the university, and I think that's an important fact, but rather a guest at a university function. So specifically, he had attended an event that took place in a recital hall. He sat towards the rear. He could not hear the presentation. He spoke with a staff member during the event and asked whether there was any hearing assistive technology like FM units, infrared systems, or a hearing loop available at the recital hall. And he was told none of those accommodations were available. After the event, he contacted the university to express his ADA concerns, but he didn't receive any response. According to the university, when a department schedules an event through their university events and conference services, their confirmation to the registration includes an accessibility notice to remind the event coordinator to consider accessibility issues and possible requests such as sign language interpreters, closed captioning, and the notice listed the contact info for student accessibility services. The university also stated that it has a portable device which can be set up ahead of time if requested in advance. Regarding the event that the complainant attended, there had been no special device provided for individuals who were hard of hearing because they didn't receive such a request for accommodation. However, OCR then, during the investigation, reviewed the invitation for the event that the complainant attended, and the invitation did not provide any information regarding availability of accessible services, activities, or facilities, or how to request any kind of auxiliary aids or services. So Title II applies here because this is a member of the public, and I do want to highlight that there is an effective communication provision in Title II. And so the legal standards in Title II state that schools must ensure that communications with people with disabilities are as effective as communications with others. So schools must provide appropriate auxiliary aids and services so that individuals with disabilities, including members of the public, have an equal opportunity to participate in and enjoy the benefits of the school's service program or activities. And lastly, this case involved a complaint as well. So the grievance procedure regulations that we discussed previously were also reviewed as part of this investigation. So the information obtained up to the date of the resolution indicated several compliance concerns. So first, it appears the university may not have had adequate or provided adequate notice for this event or other events regarding the availability of accommodations and accessibility services and how you would request such services. The university did not appear to have a process to provide necessarily auxiliary aids and services for events upon request and in a timely manner. And the information as of the date of the resolution indicated that the complainant had submitted a written complaint alleging violations of the ADA to the university, but had received no response. So here the university, it was a 302 agreement. So at that point, OCR sometimes can say, we have some concerns about, how you responded. And they might say, yeah, we also have some concerns about how we responded. And then we can, there's an agreement can be reached on how to fix that. So they had to notify the complainant about the availability of listening systems in the future. They posted a sign in the box office about the availability of assistive listening devices. They trained the relevant staff to ensure that members of the public can access those devices. They provided notice to all disability departments or employees who could hold events in the recital hall to advise of the availability of the assistive listening system and how to use it. They developed policies and procedures and training to ensure effective communication for people who are hard of hearing. And they developed language and contact information for university publications, websites, announcements, and invitations so that people can inquire about or request an appropriate auxiliary aid or service at upcoming events. So I can open it up briefly for questions. I know you had a slide earlier that said, we'll wait to the end, but Betsey, I saw you unmuted as well.
There is one question, Jasmine, in the chat.
Yes.
And
Okay.
And I can read it. It says, with regard to the case one, which was dealing with the grievance procedures, did the university have a monetary penalty? Did they fine or reimburse? Did they reimburse the student? I can address that.
You want to address that, Betsey?
I'm happy to. I'll take a step.
Yes. Okay, go ahead.
So in this case, we don't typically obtain monetary remedies, but in this case, what we required was that the university complete its own investigation of the students' allegations with regard to harassment and discrimination. And as the result of that, that's where they would determine, I believe, whether the student should be, reimbursed or allowed to take the course at no charge. That's where we don't always get that far. We sometimes ask the university to correct the process, and in that process, they would determine an appropriate response and remedy for the individual student.
Yeah, and to add on that, I'm actually going to very, very briefly just kind of summarize another case, because I don't think we'd have time to do it wholly, but I had another case. It was not about a grievance procedure, but it was about a university where the professor, the student had extended time. The professor said, oh, extended time does not apply to this class of assignments in my class. And the student had been with that professor, I think in like 3 different classes. And he said, this type of assignment, you're not going to get extra time. Also, you don't get extra time at all in class 2. And then also said in class 3, you also don't get extra time for these assignments. And so in that case, the agreement with OCR actually was that the student would be able to take classes 1, 2, and 3 over again without tuition, without having to pay tuition. So tuition was waived for those. So that's not a monetary fine or anything like that. But from time to time, there will be agreements where we do think, the student should be able to take that again. And especially in this case that I'm talking about, the second case, there was, it was like also it was a 302 agreement. It was resolved very early on in the investigation because the evidence really indicated that this professor kind of unilaterally said, no, you don't get accommodations. So the university agreed in that case, yeah, we'll let her take those classes again, all 3 classes without having to pay tuition for those. So that's a thing that can happen. But like Betsey said, the OCR does not impose fines upon people who have, engaged in any kind of violation. But sometimes we do ask that schools allow students to take a class again without paying tuition, or that refunds a tuition may be appropriate. Again, very fact specific, case by case basis for that. All right, and so moving on to our next case. Are you going to need to call in again, Kathryne? Okay. Betsey, do you want to do your academic adjustments case 0919 2021 2121?
Yes, as long as I can get myself unmuted, I'm happy to.
Yes. Oh no, I undid it, but
Okay, no problem.
Let's try that again. Okay. That's it, right? No, that's it. There you go.
Yes, thank you so much. So I'll go ahead, Kathryne. This student was involved, this student was in, is a public community college in California, and it was a student who filed the complaint in this case. The student was enrolled in the college's heating, ventilation, air conditioning, and refrigeration program, the HVAC program. And this case is a little bit different from others because it involves an outside entity. So just some background here, there's a group, it's ESCO Group, is an external organization that provides certification, accreditation, and credentialing for HVAC programs. The instructor in this course, the college's employee, chose to use ESCO Group certification tests as his final exams, but the courses were not certification courses. So when the student took when students in his class took the ESCO Group certification test as their final, they had the opportunity to earn a certification, but the course was not a certification course, and therefore the use of the group test was the professor's choice. So this didn't really raise fundamental alteration concerns per se. So during the fall of 2018, the student was enrolled in two of the instructor's HVAC classes, class 1 and class 2. The syllabus for class 1 was that notebooks may be used when taking quizzes and tests. Our student's accommodation request form that had been approved by the Disability Services Office allowed the student the use of notes for final exam. And on the form that the instructor signed, the instructor wrote that he was, the student could use handwritten notes only. So he's amending the approved accommodations that had been authorized for the student. There were lots of email correspondence back and forth between the student, the instructor, the resource center counselor about whether the student's notes for the final could be typed rather than handwritten. And this was an issue because the student typed his lecture notes from lecture recordings, and that was consistent with his approved accommodations. So the counselor initially asked the instructor to allow the student to utilize typed notes, and the instructor said no. The student knew for over a month that only handwritten notes are permitted. Then the counselor returns back to the student and said it's unreasonable to allow typed notes because you knew well in advance that only handwritten notes are permitted. The student unfortunately was also enrolled in a second class with the instructor, and this class allowed for the use of notes for the final exam. But once again, the instructor modified the approved accommodations form and wrote the final exam is an industry controlled test, so no notes or no open book allowed. Again, there was a lot of dialogue with the between the counselor and the student and the instructor, and the dean of the HVAC program also became involved. And they decided that the student had to sign a letter before he took the final exam to acknowledge that his accommodations of using computer generated notes would not allow him to receive industry certification. So I'll try to make it modified a bit and given the time, but the student also enrolled in a third course the next semester with the student reluctantly signed that letter because he was worried about further treatment by the instructor. There was a lot of confusion back and forth. I think I'll jump to what we found to be the problems. So one problem we found, was a compliance concern, was that the counselor from the Disability Services Center deferred to the instructor regarding the issue of handwritten notes versus typed notes without engaging in any interactive process with the student. So indeed, the way that the request for test accommodation form was structured, it seemed to allow the instructor to modify the approved accommodations that the Disability Services Center had agreed to. And then we also found a problem that the college had asked the student to sign a letter saying that the use of his approved accommodations would deny him the opportunity to earn a certification, which other students were able to do. And with regard to the third class, which I didn't quite get into, but the Disability Services Center had actually suggested that the student go ahead and contact the ESCO group to determine what, with regard to the certifications that were received. We found that that really was inappropriate, that would have been the college's responsibility, certainly not the student's responsibility. So this, as you might imagine, was also the college agreed to enter into a voluntary resolution agreement. The agreement allowed the student offered the student the opportunity to retake the final exam for the classes with his approved accommodations. It also offered the student the opportunity to take the for the Student Resources Services Center to coordinate with the student and the ESCO group to ensure that the student had access to the accommodations and that those accommodations would be implemented. It also required training of the both the disability services staff and the faculty. It required the development of policies and procedures with regard to exams and the provision of accommodations, testing accommodations in particular. So I'll leave it at that with our short time.
How you doing, Kathryne? You in?
I think I'm in. If you can hear me, then I'm great. Again, we rely on Apple for everything. And if we can't use our work computers, we can at least access through my iPhone. So great. So I think we're going to go through this one at a fairly good clip. So we have a couple minutes for questions remaining. I find this case really interesting, not only because it presents sort of a fascinating accessibility issue, but also because I think it's a good example of a situation where we have a student that is self-advocating and a college that clearly wants to work with a student and try to do the right thing, but there were some lingering deficiencies in the process that led to the student still continuing to have problems. So OCR's role was really working with the college to ensure that those things got resolved. So it's sort of a good example of how an OCR investigation can result in just getting those final steps taken. In this case, we had a transfer student who had registered with Disability Services, who was approved for testing and note-taking accommodations, but also and separately approached the dean of students, excuse me, that to complain that because of her physical size, she could not fit into typical classroom furniture, the chair and desk combination that was typically in classrooms. So the dean responded and tried to work with the facilities department at the college to identify furniture that the student could fit in and ensure that it was provided into her classrooms. But unfortunately, the student had experiences throughout the first 2 quarters she was at the university continued to have some problems in the classroom, making sure that the desk that was there for her wasn't moved, and continued to express concerns to the university. that she wasn't able to have immediate access to that furniture whenever she came into her classrooms. So the dean advised her to go to disability services since he was experiencing increased difficulty in providing those accommodations to her in this sort of informal way. Disability services initially denied the student's request, since their conclusion was that the student's physical size alone described a disability. So they requested and the student provided medical documentation describing an issue with leg swelling and leg pain. So the medical documentation didn't support or list as a disability physical size alone, but there were additional information in the medical documentation that was provided to disability services to support her need for alternative furniture. So disability services did agree to provide the furniture and took several steps to make sure that furniture was available to the student, but didn't provide her an accommodation. OCR conducted a complete investigation and discovered that there were simply process deficiencies that existed, including that the sort of informal accommodation that disability services was providing without formally registering the student and tracking the accommodation as it did for other student academic adjustments and other accommodations that were provided, that the student and the furniture was really just getting lost in the shuffle. So OCR's investigation involved site visits, working with the college, and the college provided ultimately information showing that they had attached Bluetooth devices to the furniture, that they had these signs placed on the furniture to ensure that facilities wouldn't move them, and that they implemented a physical tracking system so that the student would be sure to have the furniture in the correct placement in the room. And agreed to, since OCR saw that those steps had been taken and part of the complaint had been resolved, the school entered into a resolution agreement with OCR to just take those final steps to ensure that the student actually did have a formal accommodation listed and included in the university's tracking system, and that they would then have a disability resource for students who had ergonomic issues, so that the problem that the student had experienced wouldn't occur for other students who had ergonomic needs in the classroom. So I think that would conclude this case, and then the rest of our slides and our final few minutes, we're happy to answer questions that people have about this case or any of the other cases, or just general questions that you have. And Betsy, I don't know if there's anything in the chat that you could also see. If anybody wants to, you can unmute, I think, or you could put questions in the chat.
I think we've addressed what's in the chat so far.
Yes, this is Trudy. We'll give them a couple minutes. Sometimes they may be thinking about all the wonderful information that you just provided. So we'll give them a couple minutes to either post in the chat or to unmute themselves. Usually this is a very talkative group. So
I have a question.
There we go. Okay.
I have a question. So the student who was in the HVAC program and the instructor that was using the outside certifications, would you advise, if that's something that's routinely done at an institution, that disability services connect with that instructor in advance and have conversation? And even that means calling to the outside group and know that information up front to better equip the student?
Absolutely. I think that would be well advised to do that rather than to be responding to a situation, to react, rather to be more proactive. I do know the extent to which the disability services staff understood the individual instructor's preference for using that test, the certification test as the final, but I imagine that would have avoided, the working on the front end would have avoided a lot of problems on the back end.
I bring that up because we do have an HVAC program that uses a certification exam for refrigeration. So that's why I was curious to know that. Okay.
Great. Thank you.
Thank you.
There was a question as to whether we skipped one of the court cases. We did. We did skip one. I think that case is available. It's the accommodation and conduct hearing. I believe that's available on our website. I'm not sure about that, Kathryne. That was one you were going to handle, I believe.
Yeah, we did skip over that one for time, but since we have a minute here and someone's asked about it, why don't I just briefly describe that this is sort of a different environment in which we do see a number of complaints. So it involves providing an accommodation to an individual with a disability in a student conduct process. This particular complaint involved a student who had autism spectrum disorder and was the respondent in a sexual harassment hearing. So he went through the Title IX process. He argued that applying the conduct process to him in itself was discriminatory, but he had not previously registered with the Disability Services Office as a student with a disability and didn't have any kind of conduct-related accommodations. There was some information to suggest that the university may have been aware that he was struggling in the classroom prior to the sexual harassment allegation. I think a professor had even reported him for some conduct in the classroom and had walked him to the Disability Services Office to encourage him to seek supports. But OCR's investigation showed that the university had made that attempt and had sort of given him that kind of support. And so since the student was not registered as a student with a disability, OCR found insufficient evidence that the school had not appropriately accommodated the student because the Disability Services had, after the student received the sexual harassment allegation against him, worked with the student and the student's father to provide accommodations during the hearing process, including, I think that the student's father wanted to be able to speak on the student's behalf. But the university didn't permit that, but did allow the student to take breaks as needed, and the student's father could sort of reinterpret questions that were asked of the student and ask his own questions of the student. So based on all that information, OCR found insufficient evidence that a violation had occurred, either with the process itself being brought against the student or that there were requests for accommodations denied during the hearing process itself. I'm so happy to take questions on that, or again, of any of the other cases that we've covered today.
We did have another question in the chat. As a best practice, do you believe it is good to provide on the notice of accommodation letters that a statement that says accommodations that result in fundamental alteration of the academic program or undue hardship to the institution may be reconsidered? I think that certainly that's helpful for students to be aware of, whether it goes on the accommodation notice or on in the university's, the Disability Services Office website in terms of procedures. I think either way, just I think that's important information that should be readily available to students and to faculty.
Yeah, Betsey, just to add on to that, I mean, I think that a concern that I might have if that notice of accommodations was the letter that was provided to faculty members would be that you wouldn't want there to be sort of any question about the accommodations that had already been agreed upon and gone through the interactive process with the Disability Services Office. So the concern that I would have with that language being included and shared with instructors is you want to try to avoid a situation in which professors put themselves in the interactive process. So you wouldn't want a professor sort of making that determination on his or her own with the student. That's really should be happening in the Disability Services Office. So that kind of information, though, is certainly something that would be appropriate for a training of staff who are instructional staff and faculty, and certainly something that the student, and I think this is the intent of the question, to make sure that the students are aware that these accommodations that you've agreed to might be reconsidered if there's a determination made by the Disability Services Office that they're a fundamental alteration of the program. I don't know if my coworkers have any thoughts on that.
And I think that's great advice. And I just wanted to respond to one more thing in the chat. I realize we're running over time, so I'll be very succinct about it. But someone asked how they can access the individual cases on our website. So if you go to www.ed.gov/OCR, in there you'll find a reading room. And under, I believe it's in the reading room, there is a drop down for case resolutions. And in there's a search feature, and you can search by institution, you can search by the protected group, you know, for specifically for disability cases. And so there's a multiple way, or you can just type in the case number if you're aware of it, like the ones we've provided. And if the case did result in an agreement, it should be listed on that in that resource.
And there's one case which I summarized in answering that other question, and I will give you the case number if anyone's interested in that one, because I don't know why, but my little bottom ribbon where I can access the chat, I can't see it. But it's this one, 06192018. And this was the one where the professor kind of unilaterally told the student, no, you're not going to get extra time on this type of assignment, and you won't get any extra time in this class. And it was, you know, kind of a unilateral decision on the part of the professor. And so, you know, I think the only other thing that, you know, might be like something to think about as you practice is, you know, do professors know if they have questions about implementation of accommodation? Do they know how to go about getting clarification on that? So is there something perhaps on the letter that says, if you have any questions about these, please contact us here? Or is there some type of memo by the dean that says, here's how you can access the, you know, here's how you can ask further questions? So, you know, and that is a thing that comes up from time to time, kind of when you have when you're on the ground. So this might be an interesting one for you to look up. But we didn't go super in depth, but I did touch on that. And I think that should be all of the cases that we were prepared to discuss.
And just to respond, there is no chat feature on the website. However, you can contact our office. We have staff who monitor the, who have essentially talked to callers each day. So someone would, you know, our numbers just changed though.
Yeah.
I don't know it offhand. I know the old number, but we could get that to Trudy, the number, the most recent number that you can call in to get someone live to speak with.
We call it the technical assistance line.
And the Open Center also is another resource that's also on our website. They also have, you can contact the Open Center. There's a link to their, request information and speak directly with staff that provide technical assistance there. But we'll get that to Trudy. Thank you so much. I realize we're over time. We certainly appreciate your time this morning. We welcome the opportunity and thank you for having us.